Friends, today I would be talking to you about the decision of the Disciplinary Authority, whereby he remits the matter of inquiry back to the inquiring authority for further or fresh inquiry. It is in this context that we should remember the bare provisions of Rule 15, about which there is not much clarity, at least on the part of the disciplinary authority and the officers who are assisting the disciplinary authority in the context of processing of the report furnished by the inquiring authority under Rule 14. Friends, we should understand the word used, further inquiry. At times there is confusion in the minds of the persons concerned, especially in the minds of the officers who assess the disciplinary authority to come at any conclusion on the findings recorded by the inquiring officer. That the power as indicated in Rule 15.1 is in the context of further inquiry, and it is not in the context of the fresh inquiry. It is not open to the disciplinary authority to dump the inquiry report entirely and order for fresh inquiry. In fact, the word used, further inquiry, is very categoric, and it indicates only in the context of limited circumstances the IO can be directed by the disciplinary authority to hold further inquiry, but it should not be confused with the fresh inquiry. And we should remember that when the disciplinary authority remits the matter back to the IU, it is not for fresh inquiry. It is only in the context of deficiencies which are there in the inquiry held by the inquiry officer. The deficiencies on which further inquiry can be ordered by the disciplinary authority can be, supposing an important witness which was enlisted in Annexure 4 of the charge memo is not examined by the inquiring authority. It is quite possible that opportunity as is mandated to be given by the IU under Rule 14.18 has not been given to the charged officer. In that case also further inquiry can be ordered, and it is quite possible that necessary evidence which is duly listed in Annexure 3 is not taken note of by the inquiring officer, and without considering that important evidence the IO has given his report. In that context also, further inquiry can be ordered. Then it is quite possible the charged officer has introduced certain documents in his defense, and unfortunately one of those very important evidences which have a direct bearing on the articles of the charge framed by the disciplinary authority, the IO has not taken note of. Even in that situation, the further inquiry can be ordered, and it is quite possible. At times we know there are 2, 3 or more part in a particular article of charge memo, and it is quite possible inadvertently the inquiring officer has skipped one of the part of that particular article. To ascertain the mind of the inquiring officer in the context of that particular portion of that article, the disciplinary authority may order him to submit his further report. And it is in these are the circumstances in which generally the further inquiry is ordered. We should understand that there is no power vested in the disciplinary authority to order a de novo inquiry. If we assume that the disciplinary authority has such a power, then it will be a never-ending exercise. Just because the inquiry report is not in favor of the department or in favor of the disciplinary authority, he may keep on dumping the inquiry report and order further inquiry or fresh inquiry. So my submission is that no power is vested in the disciplinary authority to order a de novo inquiry or a fresh inquiry. Fresh inquiry can be only on a limited aspect which is already there before the inquiring officer, on which there is no finding recorded by him. It is only in that context that there can be further inquiry or fresh inquiry. We should remember that the further inquiry or the fresh inquiry cannot be ordered to the IO to come to and review entirely his findings, which already stand recorded in the inquiry report duly submitted under Rule 14. So these are the limitations which we must understand before the disciplinary authority orders further inquiry or fresh inquiry. If you ask me very honestly, the further inquiry can only be when on some important aspect the inquiry officer has failed to submit his report, or the conclusion drawn by the inquiring authority is perverse. It is patently, there is a mistake in his findings recorded. Evidence is suggesting something different, whereas the conclusion which has been drawn by the inquiring officer is entirely different. Except these limited circumstances, it is not within the power of the disciplinary authority to order further or fresh inquiry. So these, I think, important aspects we should not lose sight of while processing the inquiry report. If we take note of them very clearly, the precious time would get saved, and the ordeals of the charge officer will come to an end at an early date, which is ultimately the aim of the Government of India or the purpose of the disciplinary authority also. I think I have been able to make my point very clear. Thank you, friends.